Hello everybody, my name is Edward Albada and I have the unique combination of 20 years of experience as a coastal and oceanographic engineer and with an education as a construction law and arbitration. And in fact the title of my presentation today is as extracted from my dissertation as part of that master's degree. So today I'll be talking about consideration of contractual risks associated with coastal and engineering work. And I would argue, and I think we would all agree, that there are greater risks in coastal engineering than there are in terrestrial-based projects, all associated with working in and around the sea. I would also argue that the standard contract wording is ill-equipped or ill-defined to handle these specific coastal engineering risks, and as a consequence, employers minimize upfront spending, contractors' administration force reasonable contract clauses, contractors rely on the nature of uncertainties and hopefully recover some in variations later on, and the result is a lot of suspicion, delays, cost overruns, and ultimately disputes, which we all want to avoid. So my motivation is to provide some guidance to improve some of the contract clauses in the FIDIC Red Book. I was talking specifically about the FIDIC Red Book because, quite frankly, that's the most common form of used in coastal engineering, at least in my experience. So I'll identify some of the general risks and focus on 4 of the key contract clauses, drawing from precedents from case law and other literature. I'm not going to go into detail on these. They're adapted from Sim and Cruikshank, Coastal Risk in Coastal Engineering, and it's a fantastic resource for everybody involved in coastal construction. Site data. So this is a clause within FIDIC that is an employer requirement that they adequately describe the site. And clause 4.10 reads that the employer should provide relevant data on subsurface and hydrological conditions at the site, including environmental aspects. I do not consider that sufficiently descriptive for coastal conditions. The FIDIC contract guide itself refers to hydrological descriptions, is described as flows of water, which might refer to maybe currents, but to me at least, it implies a riverine type of flow and doesn't apply to waves and water surface elevation and so on. So there's improvement that can be done in that clause. In 2017, there was an improvement. They go on to say that the requirement is for topography of the site and on subsurface, hydrological, climatic, and environmental conditions. It is an improvement. They mention topography. They do not mention hydrology or hydrography or bathymetry, and there's no definition on what is climatic conditions. So both 1999 and 2017 have room for improvement. Another aspect of the site data clause is that employers must make relevant data available, and therefore it is up to the employers to determine what is relevant and what is not. Expert opinions, non-factual interpretations, and a lot of the very arduous assessments that go into a coastal project need not be required. So typically what happens is the data is provided in raw form, and the poor contractor is left up to interpret this. And as we all know, coastal data is voluminous, often proprietary, and requires an experienced coastal engineer to interpret it. And it's quite frankly unfair on the contractor. So there is, in fairness, can be adjusted to allow for interpretation and reliance on some of the some of the design reports and so on. I do note that the data must, if it is provided, must be accurate and reliable. So it's an employer's responsibility. If the data is inconsistent with site conditions and the contractor demonstrates reliance, and the employer is responsible, both in contract and in tort, and I referenced the Howard Marine case, where the owner was held to be liable in tort for fraudulent misrepresentation. because they provided an incorrect value of a barge's capacity, and the contractor relied upon it, and then the judge ruled in the contractor's favor. Unforeseeable physical conditions clause. Now, this is potentially more controversial. It's challenging and more expensive. You know, a different approach or working methodology may have to be adopted, and it is the grounds for the majority of the claims within the FIDIC form of agreement. So in 1999, they describe natural physical conditions and natural or man-made physical obstruction, and includes subsurface and hydrological conditions, but excludes climatic conditions. So there's a separation from hydrological for climatic conditions, which in our context in coastal engineering is quite ambiguous. So what happens when a hydrological condition is actually caused by a climatic condition? Does it apply or does it not? We all know that storm surges, they lead to sea level rise. Those are both hydrological conditions. But those may be caused by a tropical storm or a storm event, which is a climatic condition. So there needs to be some kind of clarification done there. 2017, there was a clarification, requires the effects of climatic conditions are completely excluded. So anything from any damages, for example, from a tropical storm is not claimable under the Unforeseeable Physical Conditions Clause, and it's directed appropriately to the Exceptional Adverse Climatic Conditions Clause. Contractors are deemed to obtain the necessary information to the extent practicable, taking account of time and cost. And this is in the 1999 version. This is in preparation of the tenders. Yet most of the coastal work is either underwater or inaccessible. So they don't have a lot of time or cost to be able to do the necessary assessments. So that's on the contractor's liability side. Yet the information should not be considered as absolute. In Obrascon 2015, the court deemed the contractor should have foreseen the amount of contaminated soil, even though the employer had provided environmental statements. And the judge reiterated that an environmental statement contained statements of opinion, and they were non-binding on the contractor. The contractor was deemed at fault because they were required to do their own studies and so on. The exceptionally adverse climatic conditions clause refers to weather that disrupts the progress of the works. 1999 version refers to an extension of time for exceptionally adverse climatic conditions. Those four words, in combination with each other, are ambiguous in itself, because weather need not be exceptional. The conditions need to have an exceptional impact. So there is some clarification needed there. There is also no standard for what is considered exceptional. The term is subjective and usually decided by the FIDIC engineer. In the 2017 version, the climatic conditions must be both adverse and unforeseeable. But throughout, so there's clarification in 2017, but throughout 1999 and 2017, there is a reference to conditions, not the climate themselves. And that has application to our industry, in that excessive waves and surge that occur after the following of the climate event itself are still applicable for exceptional adverse climatic conditions. So moving on, 1999, the adverse climate conditions need not be at the site itself. There was a change in 2017. The climatic conditions must be experienced at the site. So that's the difference. One, disruption from delivery materials by barge would be applicable in the 1999 version. In the 2017 version, it would not. So in summary, in coastal projects, a long-term data set is needed on all the criteria that may impact the site. On-site measurements need to take place as well to compare with the record, and the parties need to agree on the definition of exception. The force majeure clause, an extension of time may be given, but no costs can be recovered. So in the 1999 version, they say it may include natural catastrophes such as earthquake, hurricane, typhoon, or volcanic activity. I refer to this clause because it's the only clause that refers to a coastal storm event such as a hurricane. A hurricane must be a natural catastrophe, and that in itself is not defined. And there are several definitions throughout, case law as well as various texts, but it's ambiguous of what is the definition of natural catastrophe. And it also could be argued that there's no such thing as a natural catastrophe anymore because a lot of it is man-induced. So another performance in the 1999 wording is the condition prevents the performance rather than delays the performance. And there is a subtle difference between the two that is discussed in Fairclough 1956 case. Coastal storms are likely merely delaying to performance, not prevent. All in all, I don't think a coastal storm would apply for a force. The improvements that can be made to coastal contracts. In the site data clause, disclosure of all site information, which includes specific reference to all of the coastal conditions that we are familiar with. I've listed a couple below. And there should be a robust disclaimer for the employer's data, both in the data itself as well as in the contract wording in 4.11 or 4.10, as the case may be. In the unforeseen physical conditions clause, resolve the hydrological condition ambiguity in the 1999 version. I'm sufficiently confident that the 2017 wording is quite robust, and it's an easy switch out for 1999 users. And in the exceptionally adverse climatic conditions clause, there should be clarification on the interpretation. So events should be exceptional for location and time and demonstrated to have an adverse impact. And also there should be a definition of exceptional. So exceptional, taking the recommendation from the FIDIC guidebook of a return period 5 times the time for completion. I suggest that that is measured consistently over a 2-hour period every 15 minutes, and that would be an exceptional event. Engineers required to define the return period threshold. The contractor measures the site conditions, usually as with an ABCP or something similar. On smaller projects, it could be just visual recordings. That would be up to the party. Finally, the force majeure, they should be differentiated from the adverse weather conditions clause. So no relief from inclement climatic conditions, that would be directed to the adverse weather conditions clause. And I would recommend that that the parties use a recognizable, dependable third-party alert. For example, a NOAA tropical storm watch or warning, which would trigger a force majeure. In conclusion, standard wording is not sufficiently specific for coastal engineering projects, and there are improvements that can be made to the 4 clauses that I've discussed that would help. Thank you very much.